The topic at hand is the appropriate action plan and strategies to manage conflict. Focus being methods available to resolve conflict in terms of the Labor Relations Act. So reference to this topic is Labor Relations Act number 66 of 1995. Governance between employers and employees' dealings. Talking about the rights between both trade unions, and employer organizations in the workplace. It's not really about the terms and the conditions of employment, but rather the rights of individuals regarding fairness, bargaining, and dispute resolutions. And so let's start with collective bargaining. When we talk about collective bargaining, it's a mandate to work out a solution collectively. All parties involved must put in equal effort in seeing how they come out with the desired resolution. So they must work collectively. It's also an agreed mechanism in place for parties to discuss and resolve issues. It deals with parties avoiding or withdrawing from conflict. And I guess it's a democratic process towards integrative problem solving. And it must find ways of cooperating with own agreed rules and procedures as positive outcomes. Let's look at conciliation. Conciliation, or a simple definition, will be the act of procuring goodwill or inducing a friendly feeling. Well, the process of conciliation in the workplace to settle differences. So we're looking for a congenial way, an environment that's conducive for both parties to be able to actively participate where conflict is involved. It's in a quest to avoid strikes by workers and lockouts by management. So coming to resolve and avoiding a possible negative manifestation that could have a negative outcome when dealing with these respective parties. And this is usually presided by a facilitator. Focusing on the difference between negotiation, mediation, and arbitration. These are three methods used in resolving conflict situations. Well, let's look at mediation and arbitration. In particular, let's look at our first difference, because we're looking at negotiation, mediation, and arbitration. So in negotiation, what is the difference? Or what sets it apart from the other two, being mediation and arbitration? Well, negotiation is about coming together of parties in conflict to resolve differences and reach a solution. It's also about a deliberate process to reach agreements by consensus. It often involves compromise, meaning being prepared to concede in areas of lesser importance for areas of greater importance, and a win-win environment. In workplaces, unions and management seek to use negotiation to resolve conflicts. So that's characteristic of negotiations. Well, then let's look at mediation. Well, mediation is when negotiations fail, parties may call a mediator. A mediator seeks to facilitate settlement of conflict. He or she is likely to advise both parties as intermediary, suggesting solution. They only tend to act in advisory capacity. They are not decision makers, or they don't have the power to make decisions. They cannot impose a settlement. They must gain the trust and the confidence from parties. Let's look at the arbitration. These are usually independent persons that act as an adjudicator. They're there to judge disputes and decide on settlement terms. So they have more an aggressive way of dealing with mediation. They are more empowered. Parties, both parties or parties involved, will consent to the adjudicators or the arbitration's appointment. Decision of the person who adjudicates or judges is binding to all parties. So it differs from mediation and negotiation in that it does not promote the continuation of collective bargaining. The person who's the adjudicator or judge will listen and investigate and then take overall role of decision making. They can act as a singular or a panel of adjudicators and judges, depending on the nature and the gravity of the case or conflict at hand. And that pretty much sums the difference between negotiation, mediation, and arbitration.